Thank you for joining Jennifer Trust and Associates in our 2019 Webinar Wednesday series. We are coming to you live from downtown Washington, D.C. Our webinars are every Wednesday and today, Tuesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her directly with contact information you'll see on the last slide. All right, that's just a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from risk analysis reports to proposal writing and also post-award compliance. Information is on our website, so please visit us there. We do offer advertising in our newsletter, so you can reach out to us at this email if you'd like more information on that. All right, let's go ahead and get started. Our speaker today is Mary Beth Bosco, and she's going to be covering M&A and Government Contracts 101. Thank you for joining us today, Mary Beth, and I'm going to go ahead and hand it over to you.
Okay, great. Thanks, Mallory. If you could go ahead and advance to the first slide. This is an overview of the topics that we'll be covering today. The goal of this session is just to talk about the very basics of deal structures and other common and sometimes problematic issues that arise in transactions involving government contractors, whether they be mergers, asset or stock acquisitions. And also some of this is also applicable to an entity that might be lending money to a government contractor. So first, we're going to talk about the deal structure itself and how that impacts things like novations or change of control permissions. We'll then segue into what happens when a small business is acquired and no longer is a small business. How is that handled? And then finally, we're going to deal with issues relating to foreign ownership control or influence, specifically when either a foreign company or a U.S. company that might have some foreign funding sources or foreign people on its boards acquire a contractor with a facility clearance. What does that do to both the timing and the structure of the deal? So if we could advance to the next slide, that would be great. And we're going to talk about deal structure. So there are, basically three forms that these deals comprise. The most common is a stock purchase. So basically what happens is that the buyer will purchase all of the outstanding stock of the target. And with that stock purchase, the assets and the liabilities of the target company go with the sale. So in most cases, and probably the easiest structure of all, is where the buyer really keeps the target as an intact entity and positions it as a wholly owned subsidiary of the purchaser. The reason that's done is because it certainly makes the integration of the two companies much easier. And it also, if done correctly, can house the compliance obligations entirely within the entity that's been purchased. In other words, if a company that is not typically a government contractor purchases a government contractor, the optimum structure would be to keep it as a wholly owned subsidiary so that, for example, if the subsidiary is audited by DCAA, making sure that the audit is only of the subsidiary's books and doesn't somehow reach the purchaser, the parent company. We also see asset sales, particularly these days. What we're seeing is a lot of purchasing and selling of IDIQ contracts, like an Alliant contract or an Oasis contract. It's a good way for a company who wants to get into that market by purchasing the contract from another company. There is an interesting tension there because with an asset purchase, as we'll talk about in a minute, the contract has to be novated to the buyer, which is something the government must approve. So there's always a lag between the actual closing of the transaction and the novation of the contract to the buyer. So there is a time period we need to pay attention to and make sure everyone knows who's doing what during that, something of a gray area between closing and novation. You will also see, not as commonly, mergers of two companies, either equals or very close to being equals. So two companies become one. There's a new name, there's a whole new structure. That is probably the most complicated structure to pull off. Obviously, since it's a new entity, all of the contracts of the two prior companies will need to be novated. You've also got immediate integration issues in terms of things like your indirect rates, and also if the two merging companies have, let's say, they both have GSA schedule contracts, or they both hold an Alliant contract or another IDIQ, you must sort those things out. So to summarize this slide, the optimum in terms of, I think, the ability to isolate compliance and liabilities, and also to have time to integrate the new company, is the stock purchase. Can we go to the next slide, please, Mallory? There is, in government contracts, the notion of something called a novation agreement. And what a novation agreement is a three-way agreement between the government, the selling company, and the purchaser that substitutes the purchaser in the shoes of the seller. In other words, the normal rule is a government contractor cannot just transfer or assign a contract to another party. It must do so through a novation process. Novation processes are, they always take longer than you think they're going to take. It begins with a submission to the contracting officer, and that submission will be a joint submission by the seller and the purchaser. It will include things like a novation agreement, which is prescribed by the Federal Acquisition Regulation. The language is standard. You'll also have to submit things like financial statements of the two companies prior to and after the transaction, legal opinions if the transaction was affected in accordance with law, the list of contracts affected, the actual asset purchase agreement. And then there is always a give and take back and forth between the government and the parties to the transactions. We tell our clients it's typically 6 months these days or longer for a novation agreement to be processed by the government. So what that means is, as I said before, you've closed a transaction. You then apply to the government for the novation. It is done post-close. And then you have a situation where the government has not yet recognized the purchaser as the contractor. In the government's eyes, until the contract is novated and it has modified the contract, the seller still remains the contractor. So what typically is done is that the seller and the purchaser enter into a subcontract pending novation, which sets forth forth the rights between the two during that gray area pending novation. It will say who's submitting proposals. It will say, who's responsible for performance, who's responsible for communications, etc. But it's very important to have that document. For stock purchases, 99% of the time, you don't need a novation agreement. As we'll show on the next slide, there's a notice requirement to the government, but no consent requirement. Also, when you're looking at purchasing a federal government contractor, more likely than not, that contractor will have subcontracts. And whether or not some type of an approval is required by the prime contractor is on a case-by-case basis. So the purchaser. So can we go to the next slide, please? We were talking about the notification requirements under the federal acquisition regulation. Even when there is a merger, there is a notification to the government that there's been a change in ownership, and that applies to stock ownerships. It's again post-closing. The other notification requirement, which will segue into our next topic, is for small businesses. So a small business who holds a federal government contract will need to notify its contracting officer within 30 days of closing and recertify its size standard. Now, it may no longer be small because of the transaction, but that should not impact existing contracts. In most cases, that small business can keep existing contracts. The real change is that the contracting agency will not be able to, will not be able to take credit as a small business purchase for the dollar spent with that entity. Next slide, please. So the general rules when you were talking about the acquisition of a small business, where the acquisition, because of the affiliation rules, caused the small business that was acquired to lose its status as a small business, is that if a company is small at the time it submits its offer, it stays small throughout the life of the contract. So, as we said, a small business in most cases that is purchased and is no longer small will be able to keep that contract as a small business, and will even be able to bid on task orders, for example, under the large IDIQ contracts, so long as the contracting officer does not require the small business to recertify its size standard when it puts in its offer on a task order procurement. So a question that you might want to ask in due diligence when you're looking at a small business that has a number of task order contracts is whether or not there have been any discussions with the contracting officer or about whether the CO will require task orders to be recertified, or what has been the practice in the past. The other exception to the small business rule is BPAs, because obviously a blanket purchase agreement, when it is, you may win it as a small business, but you are going to have to bid on separate contracts under the BPA. And for each of those contracts, you will have to qualify as small to bid on that. The other difference here is 8A contracts. An 8A contract must be terminated upon an acquisition that causes it to no longer be owned by a socially and economically disadvantaged business, unless the SBA grants a waiver. And the agency, the contracting agency, must support that waiver request. So that's another big sort of gatekeeping issue when someone is contemplating purchasing an 8A business. What will happen to that source of revenue? And then finally, we're going to close with another gatekeeping issue, which is foreign ownership, control, and influence. This applies to contractors who have facility clearances. So the most stringent rule here is that a government contractor with a facility clearance cannot close an acquisition by a foreign owner. So if a foreign company wants to buy a US company with a clearance, it must have the permission of the Defense Intelligence and Counterintelligence Agency, whatever DSS is now called, in order to close. So that obviously will build in timing, a timing period in any transaction. You've got to leave at least 60 days for that process to work itself out. In the case of foreign ownership, the government will require its contractors to either employ what's called a special security agreement or a security control agreement, which basically sets up a special security committee, government security committee of the board, and sets up a monitoring system and periodic reports to the government to show that the foreign owner cannot control the US company. In the alternative, companies can use a voting proxy agreement, whereas under which the foreign owner interest will be voted by a proxy. Mitigating foreign ownership, control, and interest and influence is much easier when what you're talking about is maybe a passive foreign investor, particularly the case when one of a private equity fund has foreign investors. In those cases, for the most part, companies can use a board resolution that excludes those investors from access to classified information as their FOCI mitigation measure. So when there's foreign ownership, control, or influence in whatever form, the government will require some type of mitigation, but the form of mitigation is dictated by the degree of foreign ownership and control. Obviously, foreign ownership calls for the most stringent types of mitigation plans. And with that, I think we are just about done with this, and I'll turn it back to Mallory to make sure we are staying on time.
Thank you so much, Mary Beth, for sharing your knowledge and insight with us today. If you have any questions, please feel free to reach out with her at the phone number or email shown on your screen. This concludes the webinar. Thank you.